Good morning, everybody, and welcome to the First District Court of Appeals. We have 5 cases on our docket this morning. 4 have been submitted and 1 is to be argued. We will begin with the case that is being argued this morning, and that case is Miami Township Board of Trustees versus Wineley. Counsel, you each will have 15 minutes to argue. Mr. Muthing, as the counsel for the appellant, you will be able to reserve up to as much time as you want for rebuttal. And whenever you're ready, you may begin, but how much time would you like to reserve this morning?
Good morning, Your Honor. I would like to reserve 3 minutes for rebuttal.
All right, and whenever you're ready, you may begin.
Good morning, Your Honors. May it please the court. My name is Brian Muthing, counsel for the appellants Michael Wineley and some entities for which he's associated with. Your Honors, this case is a nuisance case. It concerns property on the west side that is in its current form little more than a pile of dirt. And in most respects, that's all that it has ever been. Nevertheless, the plaintiffs below brought this suit to enjoin a possible and indeed a possible use of the property. And the trial court granted a sweeping injunction against future use. Your Honors, there's procedural and substantive issues with that order that require reversal. Your Honors, I'll start with subject matter jurisdiction because I know this court has often observed that it's extremely important that all courts be particularly important to guard whether or not it has appropriate subject jurisdiction. Your Honors, the case below, by the time it reached a permanent injunction hearing from which there is an appeal on today, the case was moot. It was moot because when you look at the complaint was all about possible racing that may or may not occur in the fall of 2019. By the time that the trial court entered a preliminary injunction, a temporary restraining order that put any hope of that racing out of the possibility. By the time we got to March and April of 2020, the possibility that that racing would occur, if it ever was going to, in the fall of 2019 was over. There was nothing left for the trial court to do. And we brought that concern to the trial court in a motion to dismiss, and the trial court rejected that motion, and that was error. The dispute was over. There was nothing left for the court to do. And in that regard, the trial court overstepped what jurisdiction it had. The issue was compounded by any concerns that the litigation would concern future racing. Indeed, the possibility that racing might happen in the future was so contingent and so uncertain, and in whatever form it might take, that any concern about potential future nuisances were not ripe. And I can tell you why for a few reasons, Your Honors. This track was not completed. The form in which this track might become complete was unclear. Our brief in the record below shows that there were many steps that would need to be taken for racing to ever occur on that site. Mr. Wineley testified below that in that interim period, the time between when the trial court entered its temporary restraining order and when the permanent injunction hearing happened, that there were life events, including the death of his father, his ascending to potential control of a drag strip that was nearby, and his essentially running out of money, all of which put racing there in pretty substantial doubt. But past that, no one knew how often the track might run, what cars might run, what time of day, how many races, and this is all laid out in our brief, but suffice it to say, Your Honors, the possibility that this track might not run was pretty substantial. And so when the trial court, when we had this permanent injunction hearing, essentially everyone was guessing what the future use might look like. And if you look at all the plaintiff's fact witnesses that were offered below, they all admitted that they did not know what a potential schedule might look like. They admitted that if this track ran infrequently, or if it put in mechanisms to deal with dirt and dust or potential noise, that there might be circumstances in which this property would not become a nuisance. But in the end, we were all just basically guessing. And the reason for that is that the circumstances were not clear. And from a subject matter, excuse me, jurisdiction perspective, what that left us was really just guessing. It was essentially an advisory opinion. Like, if the trial court essentially said, if the trial court, if the track opened and if it ran on these particular circumstances, then it's possible it might be a nuisance. But no one knows. No one knows. And that really implicates the possibility that this was simply an overreaching opinion in our view, for which there was not subject matter jurisdiction. The issue is similar and related when you actually get to the merits of the dispute. Everyone agrees, I made this point in our brief, everyone agrees that there is not a current nuisance out there. The plaintiffs don't contend as much. The trial court's opinion does not suggest as much. No one really could. So this puts us in the situation where it's an anticipatory nuisance, which, I'll be candid, of course, the law recognizes that as a possibility. However, it elevates the standard that the plaintiff must achieve when they are reaching for an anticipatory nuisance finding to a substantial degree. And we lay out this standard in our brief, but it's pretty well accepted. It starts from the idea that the evidence must be clear and convincing. Your Honors, the evidence here, as we lay out in our brief, I'll just very quickly summarize, was not clear and convincing. All of the witnesses that the plaintiffs called as fact witnesses, the plaintiffs, essentially the neighbors that lived around this property, could not testify with any certainty that this track might become a nuisance, because they admitted candidly they had no idea what the proposed use might end up being. The expert witnesses that they proffered, one testified as to sound, one testified as to potential dust. The way they did this, Your Honors, was to go to visit other tracks. Of course, there is no racing at this site, so they went to these other tracks, and they candidly admit that their entire opinions are built upon the assumptions that racing at this site would look exactly or mostly like it does at those sites. But on cross-examination, they all admitted that the racing here could look way different. It could be on a different schedule. Go ahead, Your Honor.
May I interrupt and ask a question?
Absolutely.
Let's assume that the anticipatory nuisance is the operation of the track, and assume that the court correctly found that operation would be an anticipatory nuisance. Wouldn't remedy be then to allow your client to continue to build if it wanted, knowing that operation might be a nuisance, and narrow the scope of the injunction?
Your Honor, there's no question that the scope of the injunction is overbroad. There's no question. It is for the reason that you say, that for many, many months, a year, the construction of this track went on. And there was no suggestion, there was no litigation, there was no cease and desist. And so the construction is not a nuisance. And I don't think anybody claims that it is. But going further, Your Honor, there are ways that this track could be operated in ways that might not become a nuisance. For example, Mr. Wineley could run cars out there on the dirt that are not souped up race cars. They could be run with high mufflers. They could be run that are not substantial performance cars. It could be motorcycles. It could be bikes. It could be human beings on their feet. And that gets to the real point. We don't know how this would run. But I don't even accept, Your Honor, that one day or 1 week or 5 nights a year, that even running a dirt track there would be a nuisance. I made a reference in our brief to how a 4th of July parade is really loud and it brings lots of people and crowds, but we let that go because under the right circumstances, under the right timing, under the right schedule, with the right mitigation, That's not a nuisance. That's just what people have to accept as part of their lives. And the other thing I'd say, Your Honor, about this particular property is that it sits in the shadow of a drag racing strip. There is already substantial automotive noise down there. So there is a strong possibility that were it finished, that were a schedule maintained, that were a schedule built, that it could either fit into the existing essential noise down there, or you could have a situation where it's so limited in use that it's not a nuisance. And in fact, if you look at some of the other racetrack cases in this state, nearly all of them permit either personal use or use up to a certain time of day. And, that's it really gets to the fact that the scope of the order is substantially overbroad. What I think the right result here is, Your Honor, candidly, is just a straight reversal on the fact that it was overbroad and unclear. But that doesn't leave the plaintiffs without a remedy. If you make that decision, if you just reverse and say the old contemplated racing was taken care of, you got your injunction, that didn't happen. Moving forward in the future, I can see that maybe there might be times when if they race too often or too loud or under a certain schedule, it might be a nuisance. But let's let those facts develop. Then you can come back to court with an actual ripe concern. Then we can have litigation on concrete terms. That's what the problem here is that no one knows. It's all just a guess.
And you have about 1 minute left.
Mr. Muthing, you seem to be arguing that the court would be required to wait until the track opened to determine whether or not this was going to present a nuisance. And yet there's lots of case law that indicates that you can recognize an anticipatory breach. Want to comment on that?
I do, absolutely, Judge Hendon, and I think that's a really important point, and I appreciate you making it. No, I do not suggest that the track would have to wait until it was built. I think we need to, first of all, gain clarity, gain evidence that the plaintiffs would have to bring that would show that it would be finished. Then we would have to have clarity as to what cars might run and what schedule might be, both like, is it going to be 3 times a year or 150 times a year? My client candidly has no idea at this point and hasn't touched that property from a development standpoint in a long time. So I'm not saying you have to wait till it opens. I'm saying we have to wait till there is some actual clarity as to what we are trying to enjoin. If and when he were to finish this track, he would make an announcement that would say, here's the schedule I'm trying to run. I'm going to run, these souped up cars. And the plaintiffs could say, well, those are the exact ones we're worried about. And this is 25 nights a year, and that's too much. And when we get those facts, then I think there is fair litigation on, candidly. But until then, we are really just guessing. And it's impossible to do an anticipatory nuisance case when you can't say what you anticipate. We have candidly no idea what that might look like.
Let me ask you, Mr. Muthing, in the first prong of your argument, you discussed the fact that track wasn't complete, but I thought somewhere in the briefs there was some indication that racing was imminent in that there was one scheduled within a couple weeks. Is that correct?
That's a great question, Your Honor. So, Judge, there was a Facebook post that our client threw up and said, we are intending to have racing, and I think it was about 5 weeks away. And it said, and that's what triggered this litigation. There was lots of evidence in the record through our trial brief in particular, where Mr. Wineley said, actually, I still had to do these, 4 or 5 things. I didn't have permits from the state. I didn't have, this completed. Mr. Wineley, I think, testified candidly on examination that he was not ready and would never have been ready, and it was aspirational in nature. He said that. He put it on Facebook, but even granting that, Your Honor, that's what the temporary restraining order took care of. It was moot by the time we actually got to real racing when there was no plans anymore. And he testified, importantly, that his interest in doing this and candidly his resources for doing this have largely evaporated. And so when you look at the future, it was unclear. And may I just finish briefly? That gets to the point too, where a day of racing may or may not actually be a nuisance.
And you are at your time if you would like to reserve 3 minutes, unless the panel has any other questions. Any other questions at this point?
Actually, yes. Sorry to take up your time, Mr. Muthing, but under your second argument, and I don't know that Miami Township would ever do this, but with regard to the drag strip that's there and in existence, your argument seems to be is that, well, then they could file a nuisance action and injunction against the drag strip. Do you believe that to be correct?
Your
Since it's
Honor,
in existence and
there is,
in
I'm sorry.
operation.
Your Honor, I will pull it up as we're talking, but I will tell you that as we went through this litigation, there was no suggestion that the township was interested in doing that. And if you look at the complaint that started this all, Your Honor, at paragraph 4, the plaintiffs say, importantly, plaintiffs do not seek to prohibit Edgewater Sports Park and its drag racing from operating. That track enjoys a long, successful history in the area, 65 years, et cetera. So
Okay.
I think the plaintiffs were pretty upfront that the drag racing strip was not something that they sought to enjoin. I think they would have had a hard time after all these years. The distinction that they were trying to draw, Your Honor, was if you go and look at the complaint, goes throughout this, is that dirt racing is noisier and longer and dirtier. That is, it kicks up a lot of dust. And that really gets to the point that I've been trying to make, which is maybe not. Maybe not. If you run one race on a short timing, it's not likely to be any noisier. It's not likely to be any dirtier. It's not likely to be any more disruptive to the neighborhood. There is a world, I want to be candid, there is a world where I can see that this proposed dirt track, if used in a certain way, would be a nuisance. But I can't say, my client can't say, and I would submit my counsel at the bar can't say that we are going to for sure reach that world.
Thank you.
Any follow-up questions for Mr. Muthing? No. Thank you, Mr. Muthing. You will have 3 minutes for rebuttal.
Thanks, Judge Myers.
Mr. Razzagi, you may begin whenever you're ready.
Thank you, Your Honor. May it please the court, Ali Razzagi on behalf of the plaintiffs in this case, the Miami Township Board of Trustees and the individual residents who brought this lawsuit. I'll address the arguments that Mr. Muthing raised in the same order, beginning with the subject matter jurisdiction. Mr. Muthing argued that there is a level of mootness here because there is no longer a possibility of racing in 2019. That schedule was over by the time that the trial had commenced. While that may be the case, that doesn't mean that there's not going to be any racing in future years, 2021, 2022, 2023. And the fact that Mr. Winley stopped constructing the dirt track in compliance with the court's order, the TRO that was extended by the parties on agreement, does not mean that the claims became moot. It just means that he is complying with the terms of a TRO. As far as the ripeness argument, and this seems to be a very central tenet of Mr. Muthing's argument, which is that it seems he's arguing everything here is speculative, that we don't know exactly what this dirt track is going to be like because we don't know the precise schedule, the precise cars, the precise number of races that they're going to run on the precise days that they're going to run them. And so therefore it's too speculative. I will submit to your honors that I've never had a bowling alley inside my house before, but I know enough, I've been to enough bowling alleys to know that it's going to be very, very loud. Same thing with the dirt track. Even if we don't know whether it's going to be run on a Monday or a Tuesday, we do know from dirt tracks in general that they are loud and that they are noisy and that they are dangerous. And that's exactly what the trial court based its decision on in finding, supported by clear and convincing evidence, that there wasn't in fact a nuisance here. The anticipatory nuisance is not speculative. The proposed uses of this dirt track are not speculative. Mr. Winley even testified in his own deposition and at trial. According to him, by his own admission, while there is some minor work that still needs to be completed, he could be up and open within a week. In a week. That was his own testimony.
Mr. Razzagi, if the anticipatory nuisance is the operation of the track, why isn't the court order overbroad that would require him remove things that are already constructed. And in other words, if he wants to construct something that maybe he can never use, who's to say he's not free to do that?
Your Honor, the case law in Ohio is clear that a trial court has broad discretion in framing the scope of injunctive relief. And there is precedent, and we've cited such precedent in our brief, where a trial court has enjoined not just the operation, but also the construction of a racetrack that was found to be an anticipatory nuisance. So there is precedent for that. And because the trial court has discretion in fashioning the scope of a preliminary injunction and permanent injunction, I submit to your honors that this was clearly within the judge's discretion, and it was not, and counsel has not demonstrated an abuse of that discretion by the trial court.
Mr. Razzagi, I'm sorry.
Go ahead, Judge Hendon.
Did the township specifically request that the Winleys remove the whatever had been done up to that point? I can't find anything in here that indicates that that was the issue. The issue seems to be simply shutting down what was moving along to opening.
I based on the papers alone, I believe that recollection, your honor, is accurate. I believe in our papers, in our original complaint, and in our motion, what we submitted was a request to cease construction. We did request an injunction to cease construction and to cease operation. I don't know if we specifically requested the specific order of tearing down what has already been constructed.
And could we do just a little procedural house cleaning here? I understand from the footnote, I think it's on page 21, if you read, is the township waiving attorney's fees?
Your Honor, I believe that the issue of attorney's fees is premature at this point because it has not been adjudicated by the trial court. And I don't believe that poses or in any way divests this court of its jurisdiction, because this is not one of those situations where the request for attorney's fees is an element or part of the cause of action, part of the claims that for the plaintiffs are seeking in this case.
Thank you.
Judge Myers, were you going to ask a question as well?
Judge Hendon actually asked the question I was going to ask, so thank you.
And you asked mine.
So going back to the ripeness point, we were talking, I believe Mr. Muthing described this site as a pile of dirt, that it's been a pile of dirt and that it's always been a pile of dirt. And I would submit, your honors, that this is one incredible pile of dirt, if that's exactly what we're going to call it. There has been $500,000 invested by Mr. Winley, according to his own testimony, $500,000 already invested in constructing this dirt track. In addition to hiring engineers to draw up plans and conduct studies, in addition to obtaining all the permits to construct the dirt track and its various components, there have already been components installed to date, or at least up until the point of the trial. The concrete barrier wall and footers were all already in place. The pillars for the barrier fence and most of the cable securing the barrier fence were already in place. The light poles and the lights were already in place. Restrooms were already in place. There were 2 different driveways that were installed for ingress and egress already in place. All of that stuff was there. And as I said before, Mr. Winley, by his own admission, testified that this thing could be up and operational to the point where he could at least start racing within a week, even though there's still some work that needed to be done.
And just to make absolutely clear, none of what had been done up to the time the injunction was filed violated any kind of zoning or covenant. Everything was done, I presume, from what I'm reading, legally, correct?
As far as the township and the residents are concerned, Your Honor, I believe so. I don't want to speak for the municipalities or the county and the proper zoning issues that we were not involved in. So I would defer to the appropriate governing bodies there. But as far as we know, it seemed as if all the permits and everything were in place. Everything was good to go. We had no reason to believe that it was wrongfully obtained.
Thank you.
Getting to the merits of the issue, there was clear and convincing evidence here to support the trial court finding that the proposed use of that dirt track was going to constitute a nuisance. If we look at, first of all, there was a public nuisance. All right, we heard testimony from the Assistant Fire Chief Brian Lacey, as well as Trustee Paul Beck, who clearly testified about the strain on fire and EMT services that would be caused by the construction and the operation of this dirt track. We heard Mr. Lacey testify that the noise levels are going to be incredibly elevated during the races, and that hearing the sirens of fire ambulances is going to pose a problem. We heard them talk about the issue, the issue it's going to have on traffic, the impact it's going to have on traffic. There's going to be significant traffic delays, especially on a road like East Miami River Road, where you got 5,000 to 6,000 people attending this event. And both Mr. Beck and Mr. Lacey talked about how that's going to impact the safety issues and the traffic issues in that area. And then, of course, there's the experts. We had Mr. Eric Zwerling, who was our noise pollution expert. He talked about the effect of the noise pollution is going to have on once the track is operational. And then we also had Steven Zulecki, who testified about the dust pollution effects. Each of these guys talked about that. Mr. Zwerling said that if you are during a race, if a resident lives half a mile away, okay, so we're not even talking about the nearby residents, we're talking about throughout the township, residents who might be half a mile away would perceive the sound from the dirt track to be 6 times louder than if there was no dirt track. Okay, and the dirt track is completely separate from that drag strip where you have a 2-second race and long intervals in between. A dirt track is completely different because a dirt track, the cars are going the entire time. They last 20, 30 minutes, going around, loud noises constantly. It's not just one loud burst and that's it, as you would hear in a drag strip. The dirt track involves continuous loud noises. Same thing with the pollution. Mr. Zulecki testified that the dust emissions next to and nearly a mile away from the dirt track would significantly exceed the acceptable standard that was allowed by the U.S. EPA. So those are the public nuisance claims. And now for the private nuisance claims. We heard testimony from each of the residents. We had 3 residents that testified about what they like to do, how something like this would interfere with their ability to use and enjoy their property. You heard examples such as gardening, relaxing on the porch, barbecuing, hosting cookouts, playing outdoor games, laying in the hammock or watching TV. These are all some of the activities that these residents enjoy doing that would be significantly interfered with the construction and operation of this dirt track. Again, as far as Mr. Zwerling, our noise expert testified that during the races, the levels would be at 95 decibels. That's the equivalent, as he testified, that is the equivalent of 4 jackhammers being 50 feet away from their homes. Now, going back to the point that Mr. Muthing raised again, that this is all speculative. Let's just wait to see how this is going. We don't know what it's going to be like. We don't know what this dirt track is going to be like. It could be different. Okay, that while that may be the case, we know enough about dirt tracks to know that they are loud. 4 jackhammers being 50 feet away from your home. That's the perceived loudness to these residents. That's how it's going to interfere with all of these activities we talked about. Same thing with the dust emissions, as Mr. Zulecki testified that the dust emissions at each of the residents' homes will exceed the amount recommended by the EPA by more than 6,000%. 6,000%. So these are the significant impacts from both a noise and dust standpoint that is going to be felt, and each of these is real. None of these are speculative. These are all anticipatory nuisances, and there was clear and convincing evidence in the record, replete with clear and convincing evidence in the record to support the trial court's findings that the continued construction and operation of this dirt track would constitute an anticipatory nuisance. I'm happy to yield the rest of my time if there are any questions from the panel.
Any questions from Mr. Razzagi? Thank you. Mr. Muthing, you have 3 minutes left. You're on mute, Mr. Muthing.
I'm sorry. I knew I was going to do that. Sorry, Judge Myers. A few just very quick comments with respect to what Mr. Razzagi said. I bet he doesn't have a bowling alley in his house, but I bet he's thrown some fun parties. And I bet they occasionally had some parking on the street and some loud noises and some music and some crowd, and maybe even stayed up late one night. And that's okay. I bet none of his neighbors sued him for a nuisance because it doesn't happen all that often. It gets to the point that you need to know what the contemplated use is before you can declare something a nuisance. And he all but said, no one knows here. He gave you a lot of facts and a lot of jackhammers, but no one knows how many cars are going to run on this site, when, on what time of day, etc. Those are all unknown facts. To make the point, he talked about the township administrator, Mr. Beck. If you go to our trial brief at page 4, you can see him give back every game by saying, I have no idea what schedule, and that really matters. A couple other things. He talked about the fact that it was about to open. At page 16 of our trial brief, Your Honors, there's a fulsome discussion of all the things that needed to come. It was a lot of work, a lot of permits that would be needed from government officials that he didn't have. Judge Hendon, you asked about zoning. Judge Hendon, this is an unzoned part of the county. There is no zoning down there. There was no suggestion that anything was in violation of anything. And that really kind of gets to a side point, which is they wish this was zoned. They wish there were requirements that limited use and limited noise and limited operation, but there isn't. And they're trying to impose zoning through a nuisance action, which is really against the will of the government and the voters who have chosen not to zone this area. The last thing I would just say, Your Honors, is about the scope of the injunction. I just reiterate, I candidly and respectfully do not think it's enough to reverse this trial court and say, well, he can finish building. Because there are many uses of this property, many uses that may or may not become a nuisance. And I think it really is premature at best to say, if he were going to operate this track 1 day, 3 days, 5 days with certain cars that were limited, with certain mufflers, to say that that is a nuisance, because there's no record of that. Certainly not a clear and convincing record where we can say, and none of this is prejudicial to the township. My client, I love him, but he's a bit of a blowhard. I'm telling you, this track may not open, in which case we have an advisory opinion on this Hamilton County court record, which is not helpful for anybody. We need a concrete factual record, and then they can come to court and say, now I see it. The track is done. Here's the schedule. Here's the cars. Here's how often they're going to run. That's a nuisance. I need a TRO. And then I need another round of injunction briefing, which is fine. That's not prejudicial to them. But the alternative, leaving all this in place, is very prejudicial to my client. Thank you, Your Honor.
And you are at your time, Mr. Muthing. Thank you both very much for your arguments today. We will take the case under submission and give you a timely written opinion. That will conclude this session of oral arguments for the First District Court of Appeals. Thank you both.
Thank you, Your Honors.